Good morning. This is the Energy and Carbon Management Commission for the state of Colorado. It is Friday, the 15th of November at 9 a.m., and we are here for a business agenda. We'll start with acknowledgement of our existence with a roll call.
Thank you, Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner Mesner,
Here.
Commissioner Oath,
Here.
Commissioner Ogletree, Commissioner Robbins.
Here.
Mr. Chair, you have 5 commissioners present.
All right, great. All right, folks, this is a continued hearing from Wednesday the 13th. We had a couple of matters on the agenda then. We have a couple of matters on the agenda today. We're going to start with docket 230900310, an oil and gas development plan proposed by Bison Operating. Let's bring that attorney and panel to the fore.
Thank you, Chair. I'll just make sure our panel is on. We were sworn in on Wednesday. Would you like to swear in again or?
No.
Okay.
As long as you don't have new panelists that were not sworn in, they will remain under oath and testify truthfully in all the foregoing, so we should be good.
Okay. Looks like we've got our team on. We've got a short presentation today. So I will have our PowerPoint brought up and I'll get started. There we go. I think it just needs to be in presentation mode. Okay. Perfect. Good morning, Commissioners. Kelsey Wasilnicki with Jamie Jost of Jost Energy Law, and we represent Bison Operating 4 in the Remora 6 OGDP application. I'd just like to kind of recap where we left off the hearing on Wednesday. As you know, the OGDP was continued, and we really do appreciate the time on the agenda today to clarify a few questions on truck traffic. During Q&A and your deliberations, several questions were raised regarding projected traffic counts. Bison testified to estimated average daily truck trips during the first occupation, and these numbers were then questioned by staff, which resulted in Bison reevaluating its testimony on the spot at hearing on Wednesday. Today, we would like to affirm the originally stated average daily truck trips during the first occupation and explain Bison's testimony and rationale. We would also like to acknowledge the relevant law and rules around local government siting disposition. Bison recognizes the Rule 302C3 deference to local government siting and affirms that Bison will not commence operations for the drilling of a well without an approved AUSR. We do believe this was also acknowledged by the commissioners on Wednesday, but we want to make it clear that this OGDP is approvable today, that Bison complied with all applicable rules regarding CPW consultation, that traffic impacts are within the local government's jurisdiction, and that the AUSR will accurately reflect the traffic figures that Bison testified to and will affirm today. So again, thank you for your time this morning. I'll pass it over to Katie Gillen.
Good morning, Commissioners. Thank you for the opportunity to clarify and correct aspects of our testimony on Wednesday regarding our average daily truck trips for the first year of production before oil and produced water pipeline is installed. I am Katie Gillen, Vice President of Regulatory Affairs and EHS, and I provided testimony that our average daily truck trips for the first year of production prior to installing pipeline would be 7 oil truck trips per day and 4 produced water truck trips per day. During the panel Q&A, Commissioner Messner questioned our estimated truck trips, stating that he believed our estimates were low for 6 wells. I clarified that our estimates and proposal would be to drill up to 5 wells, not 6, and that these volumes accurately reflected the anticipated truck trips for the first phase of development. Commissioner Messner requested that staff confirm whether our estimated truck trips were correct. Ms. Diana Byrne provided testimony that a single 2-mile lateral well would need 4 oil truck trips per day per well, which would amount to a total of 20 oil truck trips per day, significantly higher than what Bison had testified to. Miss Byrne, however, did not clearly state whether the production volumes for the wells she used to calculate truck trips were representative of the Remora wells. Nor did Miss Byrne provide her calculation assumptions for the truck tanker load volumes. All of this is to say that her testimony unfairly shed doubt on our estimates without first ensuring that her assumptions would be representative of our operations and comparing apples to apples. Without proper context or disclosure by Ms. Byrne's assumptions, there was no way for Bison to confirm whether the calculations were correct. As we worked quickly internally to evaluate our projected volumes and estimated truck trips on the spot, Don Koenig, our Executive Vice President of Reserves, testified that our estimates may have been for 2 wells and not 5 wells. His testimony was based on the fact that he provided the regulatory team with 2 well production projections, which the regulatory team needed to calculate 5 well production from. Mr. Koenig testified that those volumes may have been based on 2 well production, not having knowledge as to whether the regulatory team had completed those calculations, and felt compelled to respond to Ms. Byrne's testimony. We have had the opportunity to review our production projections and truck trip calculations and can confirm with certainty that our original testimony was accurate. Respectfully request that these types of questions by commissioners warrant the opportunity to review either in advance of hearing or in a recess session so that this type of miscommunication can be avoided by both staff and the operator. These applications include extensive amounts of detail and data analysis, and it is not always feasible to confirm the accuracy of detailed data evaluations on the spot during the hearing. Furthermore, by the time an application reaches the commissioners for decision, accuracy of the permit has been completed and confirmed by ECMC staff. Next slide. For your benefit, to demonstrate that our original testimony regarding truck trips are correct, here is our projected monthly production for 5 wells for the first year. As you can see highlighted in yellow on this table, our average daily oil production is anticipated to be 1,404 barrels per day, and our produced water is anticipated to be 648 barrels per day. A truck tank load volume is 200 barrels per load. If you divide the average daily production by the truck tank volume capacity, so 1,404 divided by 200 barrels, you get 7.02 truck trips per day for oil. And if you divide 648 by 200 barrels, you get 3.2 truck trips per day for produced water. And to be conservative, Bison rolled up our estimate for produced water from 3.2 to 4 truck trips per day. As you can see, this matches our original testimony for this application. The example provided by Ms. Byrne in her testimony estimated 4 oil truck trips per day per well, which would be 20 oil truck trips per day. Assuming a 200-barrel truck tank volume, this would mean your total daily production would have to be closer to 4,000 barrels per day, which is significantly higher than the 1,400 barrels per day we anticipate for the Remora wells. As you can see, Ms. Byrne's testimony is not representative of the production we are anticipating from these 2-mile lateral wells. The testimony, without clearly stating her assumptions, led to the confusion and doubt over our estimated truck volumes by commissioners. Again, we want to reiterate the accuracy of the application has been determined by staff, and that these types of detailed data analysis questions are best provided in advance of the hearing, or at least allowed to be addressed in a recess session where adequate QA/QC can be completed. This will avoid erroneous and misleading testimony by the operator and staff. However, we greatly appreciate the opportunity to clarify these numbers with you today. Next slide. We would also like to address concerns expressed by Commissioner Oath and Commissioner Messner based on the assumptions our truck trips may not be accurate and questioned whether our accurate truck trips were provided during the consultation with CPW. As we just previously reviewed with you all, our original testimony and estimated truck trips in this application have been confirmed to be accurate, so we believe this concern has been addressed and resolved. However, to further clarify, the Remora 6 OGDP application at the time of filing was outside of all high priority habitat for both the location and access road. Bison voluntarily agreed to consult with CPW and voluntarily agreed to construct the access road outside of the pronghorn step. As of the approved 2023-2024 high priority habitat maps, the access road is located at the outermost edge of the pronghorn habitat and is along the Interstate I-70 corridor where there is already significant traffic impacts on habitat. As a result, our operations will make no significant change to the already active area, making this an ideal location that avoids and minimizes impacts to high priority habitat. No further consultation with CPW is required, and CPW has no concerns with Bison's operations. Next slide. While it was clearly acknowledged by Chairman Robbins and Commissioner Cross in our hearing yesterday that the continuance of our OGDP was not in any way related to the pending local government disposition approval, Bison would like to acknowledge relevant legal standards under CRS 3460-106F1 that no operations for drilling a well will occur at the Remora until final local government disposition and approval of our AUSR application, and that the director's review under Rule 302C states that the director will defer to the relevant local government's siting disposition. Bison anticipates final approval by the end of November. Should anything significantly change due to local government siting, Bison would revise our OGDP accordingly. And finally, the relevant local government has primary jurisdiction over traffic volumes and counts. Bison will ensure we comply with all local government traffic requirements. Next slide. In conclusion, we believe this is an excellent location where no ALA criteria applies, and we are compliant with all Arapahoe County Development Code setbacks. There was no opposing comment received on the OGDP. Bison has agreed to construct our access road outside of the pronghorn step. And finally, staff found that impacts to public health, safety, welfare will largely be avoided, minimized, and or mitigated by the successful implementation of our BMPs for this application. Thank you for your time.
Ms. Wozlinki, anything further?
Nothing further from me. If you've got any questions, our team is here for them.
Before we subject the panel to questions, let's bring up Diana, who I think is with us. Hi.
I am here.
Were you able to listen to the testimony?
I was, yes.
Um,
Go ahead.
I was just going to ask if you had any thoughts, questions, clarifications, etc., on the testimony.
So I did run numbers with the Arkansas pad, which is immediately offset to this development, and I did get higher numbers. I don't know if they're about 20% different. When I've done this in the past, I've been told that, yeah, tanker volume is 200, but that water, because it's heavier, you don't usually see that the full 200 barrels is put on there. And so I ran the numbers with utilizing both 200 with water and 175 as water. And so I did get higher numbers. I get about 20% difference using the 4 wells directly to the west and prorating that to 5 wells. So I did get a little bit higher numbers. I don't know if that's impactful, but I did get about a 20% difference.
Okay.
Those are the
Thank you.
actual production numbers for that set of wells.
And is that consistent with how you generally run comparison numbers, i.e. taking a
Yeah,
look
and
at
to Ms. Weslinski's point, this is not the pad I pulled up on Wednesday. I just pulled a pad that I knew existed and ran those numbers on the spot. These are the actual numbers for the well that's the section over.
Yeah, no, I think we've all learned a lesson on trying to do things hurriedly in terms of hearing as opposed to taking a recess or giving both the applicant and our subject matter experts the opportunity to make sure that they're looking at the relevant wells, et cetera. So thank you very much for that information. Appreciate it. Ms. Weslinski, does your subject matter expert desire to weigh in any further, given what we just heard from Diana?
Thank you. And Ms. Byrne, we really do appreciate your insight into this. I would just reiterate, and Ms. Gillen can do this as well, the numbers that were testified to being accurate for this location in this area. So Ms. Gillen, do you want to add anything?
Sure. Yeah, Ms. Byrne, I don't think you were present perhaps for our testimony, but our average production per day for oil, we anticipate to be 1,404 barrels for the first year. So, and then for produced water, we anticipate 648 barrels of produced water on our daily average for the first year. And we're confident in these numbers. And I guess maybe I can run through our truck trips too. So we use a 200 volume tank for truck loadout. And so we anticipate 7.02 truck trips per day for oil, and then 648, 3.2 truck trips per day for produced water if you divide 648 by 200.
Okay. Thank you for that additional information. If we can drop the screen share, I'll be able to see folks a little bit better. Okay. All right. Ms. Gillen, just, one question. The commission, as it's, undertaking these sorts of reviews, is trying to get to accurate information. I just would point out that, we're not trying to, double guess or catch somebody in one way or another, and appreciate the idea that we should take a recess if we're getting into more technical, areas in which more time is needed. I would just state for the record that the commissioners are not subject matter experts in these sorts of things. And so if we ask a question and the applicant thinks it's more appropriate to take a break to analyze it versus shoot from the hip, that's really on the applicant to sort of tell us that, because I'm not going to know. And so, I just heard a little bit of inquiry this way and that way. This is a two-way street. We all got to work together in terms of how we're getting at the appropriate decision for the commissioners. And so I'm just informing applicants as a whole that if commissioners' questions are getting into a level of detail in which it really makes more sense for us to take a recess, you need to tell us that. Instead, y'all show up from the hip and you were inaccurate, and now you've got a few days to get it figured out. I'm not casting blame or aspersion in any situation. I'm just pointing out the obvious is that the commissioners are not the subject matter experts. And so we need to really work with each other to get to effective decision making. So again, not throwing shame one way or another, just sort of pointing it out there. We're all trying to do a good job for the state of Colorado. So I think that's more of a thought than it is a question. But at any rate, does folks have questions for the panel?
Mr. Chair, I've got a question.
Yeah, thanks. Go ahead, Commissioner Messner. I couldn't see everybody. There's too
So
many.
I wonder, and I'm just trying to, again, understand the numbers. And so this is a question for both the applicant and Ms. Byrne, should she want to weigh in. But when you talk about the average, is that average over the lifetime of the well, or is that average over the first year of production?
It is averaged over the first year of production. And if you recall, we plan to install pipeline for the second phase. And if you go back to our development schedule, that's within 1 year's time.
That's fine. I'm just trying to understand and make sure that I'm tying the truck tricks with the actual impact, because we have had operators that have done averages over the lifetime of the well versus the first year of production. And so this one, because there is the pipelines, that makes sense to me to have it determined in the first year of production. And so I guess that's my question. I will make a statement that, you know, I do ask questions as I see fit in order to make a determination on an application, and I'm based these questions on testimony that was provided. I think I agree with Chair Robbins that if an applicant needs to ask for a recess, I think we're all open to that. I do think we did provide that to the applicant by staying the application or staying the decision on the application in order to be able to get some clarification on these questions. You know, Rule 301A and Rule 307 both allow a commissioner to ask for additional information necessary to make a determination of whether or not an application meets the rules and the act. And I think that's what happened in this situation. And so, and commissioners and myself need to evaluate all potential impacts associated with an oil and gas development, and that includes traffic and transportation, which is why you're required to submit a transportation plan and provide information associated with truck traffic in your application. So that is part of our rule requirements for review. So,
Other questions for the panel? All right, I'm not seeing further questions. Ms. Wozlinski, anything more?
Not on our end. Thank you.
Okay, thank you very much. Okay, commissioners, this matter remains before us. We can deliberate if we so desire, or we can not. I think that for better or worse, we've sort of clarified the initial year's worth of truck traffic. Glad that we got to that. That was an issue that I think desired some clarification. Glad we ended up with this special hearing this morning to do that. I am of the opinion that the only other issue that I think remained outstanding from my regard was the Arapahoe County matter. You know, but at the end of the day, they can't do anything unless they get approval from Arapahoe County, and they've recognized that. And so, in my regard, this thing has been fully briefed, deliberated before us. I'm comfortable moving forward with deliberating on this at this point. Appreciate it's a little bit unique with sort of the dual, the coming in is sort of testing and then coming back and then doing the pipelines. But I do not find that this triggers, at least from my consideration, a negative consideration based upon any specific rule. I think it meets our rules. Those are the initial deliberative thoughts from one member of the panel. Others with deliberative thoughts? Mr. Cross?
Thank you, Mr. Chair. I'll just say I agree with you.
Others with deliberative thoughts? Commissioner Messner?
Thank you, Mr. Chair. I do acknowledge that the one outstanding piece is the local government's decision regarding siting. I think that the applicant has acknowledged that this commission is required to defer to the local government in this particular situation to siting, and should the siting change, it may constitute a significant change to this application, which may restart the OGDP process. At the commission level, I think the applicants indicated that they don't anticipate that happening. And so, but they've acknowledged that that's the case. And so I don't have a problem with moving forward with an approval of this application with that. And will continue to ask questions to make sure that the applications are accurate, and did need some clarification on that. And there still is some discrepancy there that I think will get resolved at some point in the future, because future review of operations does evaluate truck traffic for accuracy. And so based on production value that actually occurs on these wells. And so I think we have the ability to cross-reference the numbers that were provided in this application with what actually occurs once production begins on these wells, to ensure that they truly are accurate, and that the Form 2Bs that have been submitted as part of this are accurate as well. So I'm comfortable with moving forward with approval of this application, and appreciate the clarification and additional information provided.
Thank you. Others with deliberative thoughts? I would move approval of the application. Do we have a second?
Second.
Motion and a second. Further discussion? Seeing none, all those in favor signify by saying aye. Aye.
Aye.
Any opposed? Motion carries unanimously. Thank you, Ms. Wozlinski. And also a big thanks to Diana Byrne. Really appreciate her on the spot being available to provide information, subject matter expertise that we don't have. She's an invaluable cog to the ECMC tool, as are all of our professional employees. It's a lot of behind the scenes work, as is recognized by the applicant today. But we really appreciate it. You make our job much easier in terms of trying to come to the right decisions for the state of Colorado. So big appreciative thanks there. Let's take 5 or 8 and return at 9:35 and go ahead and tee up the next applicant on the agenda. I think there's a short presentation from the applicant to begin the next matter. So let's return at 9:35. All right, we are back on the record. Friday, November 15th, Energy and Carbon Management Commission. We're taking up docket 2401-00004, an oil and gas development plan. The applicant is Extraction Oil and Gas. It is entitled the Draco OGDP. We took this matter up initially on Wednesday the 13th. We ran out of daylight hours, and so this matter was continued to this morning. I've been informed by the hearings officer that CDPHE desires to make a statement in response to some questions. So we're going to start with that. I also understand from Ms. Fulcher that there is a brief additional presentation from the applicant. We will then go to that. And then following that, we will return to kind of our general uncertain state of deliberations or what we're doing next. So with that, Ms. Sorensen, you're recognized. Good morning.
Thank you, Mr. Chair, and thank you, commissioners. So CDPHE appreciates the opportunity to provide this additional clarity regarding our consultation on this application. We also value the deliberative comments from Commissioner Messner on November 13th and welcome this chance to address them. CDPHE and ECMC have worked collaboratively to foster a positive and enduring partnership. And each agency brings unique expertise. ECMC in oil and gas regulation, and CDPHE in public health and environmental protection. This collaboration ensures a balanced and well-informed approach to addressing the complexities of oil and gas operations in Colorado. Regarding Commissioner Messner's concerns that the consultation, and I'm quoting, the consultation with CDPHE lacks credibility. That's the end of the quote. CDPHE would like to address the following points to ensure accuracy and transparency here. So first, while not required, CDPHE does actively participate in the pre-application process when staff capacity allows. CDPHE was initially contacted about the proposed extraction Draco OGDP by Weld County as part of their local process in December of 2023. And we provided a written referral response within a week of their request, advising that CDPHE would require a formal to residential building units. Upon passing completeness, CDPHE's review process adhered to the timelines and procedures set forth by ECMC rules. CDPHE's understanding about the number of RBUs or residential building units within the 2,000-foot buffer changed as additional information became available to us, assisted greatly by input from the town of Erie. Any post-consultation process corrections as a result of additional information promptly. As in all of our consultations, CDPHE considered all potential public health impacts associated with this application. Our analysis specifically highlighted these risks and recommended measures to mitigate them. At the time of consultation, there was no definitive set plans for a school to be built within 2,000 feet of this proposed location. This continues to be the case, as the land has yet to be purchased by the school district in question, with no clear statement or sign of intent that they will. The difference in number of RBUs that you saw is likely the result of utilizing a 2,000-foot buffer from the interim reclamation working pad surface versus the largest working pad surface that is present during pre-production. As the planned RBUs are known to not be occupied by residents until after the pre-production phase, CDPHE stands by our use of the interim reclamation pad extent for that analysis. So in conclusion, CDPHE remains committed to providing rigorous and unbiased public health analyses to support ECMC's regulatory decision-making process. We respect ECMC's role as the permitting authority here and defer to their expertise in determining the appropriate course of action. And that's all I've got.
Thank you, Ms. Sorensen. Appreciate you coming back before us this morning. Do commissioners have questions from the information provided by CDPHE this morning? So, Ms. Sorensen, your recommendation following your consultation was there's a suite of BMPs that you recommended. I think extraction has agreed to those BMPs. That results in your consultation, feeling comfortable moving with this application, or where to put a nutshell on it?
So under Rule 309.f, CDPHE actually does not have the authority to recommend approval or moving forward as part of your processes. That said, a common component of our consultations is to recommend mitigating additional BMPs. The operators definitely agreed to those, a lot of those actually in this case, and I think we lined that out pretty clearly in our letter. So I don't think we have any additional information from what we provided in the original consultation letter and the follow-up correction about the RBUs in the development.
And this provides us with a kind of a different perspective in that we've got this operator as well as the developer of the additional homes agreeing that all the drilling and completion are going to occur before any additional homes are going to be developed. That's unique. I've not dealt with that before. I don't think we've done that before. Is that a distinction with a difference?
Yes, it is. That's an excellent question, Mr. Chair. Thank you so much for asking it. Pre-production emissions are known through ECMC's reports, annual reports. If you look at where those emissions and those risks are coming from, they are significantly increased during the pre-production phase through exposure from drilling emissions, from which are actually being mitigated or avoided in this case through electrical rigs, through minimum completions emissions from hydraulic fracturing most commonly, because it's such a large amount of power that needs to go into those. It creates a lot of emissions from the engines driving those. So that's where the vast majority of those kind of exposures come from. The other exposures we tend to look at long-term, especially in the production phase, tends to be things like trucking routes. In this case, the trucking route is actually not going through or near those houses. It's actually going away from it. So that was a consideration that we took into account when we did this evaluation.
And Ms. Sorensen, I'm going to ask a question I know the answer to, but a lot of folks that are listening in perhaps don't. Remind me of your background.
Yes, I am a petroleum engineer. Actually, I was originally a geological engineer specializing in minerals and fuels exploration. I have a master's degree in petroleum reservoir systems. I have over 20 years in the industry, mostly working for ExxonMobil around the world. And prior to this position, I was a professor of practice at Colorado School of Mines as the only professor teaching completions and drilling engineering.
Thank you. Other questions of the panelist? Commissioner Cross?
Thank you, Mr. Chair, and thank you, Ms. Sorensen, for this additional information today. I wanted to ask one clarifying question about one of the last statements you made in response to Chair Robbins' question. You mentioned that during the production phase, which is where the vast majority of these potential houses would be, comes from the trucking route. Given that there's three-phase takeaway being proposed here, does that change anything with respect to it? The truck trips would likely be for maintenance purposes at this point in time?
That's correct. And they're directly linked to whether you're doing three-phase takeaway or not, right? So if you don't have three-phase takeaway, if you don't have a pipeline for gas, a pipeline for oil, a pipeline for water, whether combined or not, then you have to take those away somehow, and that's going to be by truck. If you do it by pipeline, you've eliminated that particular vector, and you've also usually eliminated the tanks that have to hold that stuff. Tanks are known to be emitters, and so you're starting to minimize emissions there as well. So there's a lot of opportunities there that I think the operator has actually taken in this case to minimize those long-term ones. And it is important to remember that we cannot predict what is going to be even more protective technology in 5 years or 10 years or longer. That is still within the time frame of the expected longevity of fields within the DJ or locations within the DJ basin. And so there is room for operator modernization as time goes on.
Thank you. That's my only question.
Other questions of the expert witness? Thank you very much. Appreciate you being here with us this morning. Ms. Fulcher, you and your whomever are recognized for whatever you desire to present to us.
Thank you very much, Chair Robbins, and good morning, commissioners. We have a brief supplemental set of materials for you today. At the outset, or excuse me, at the conclusion of Wednesday's discussions, Commissioner Ackerman in particular had asked us to consider some of the couple of outstanding items and come back to you if we had any updates. And we do have a specific update on community outreach and an additional commitment there, as well as wanting to make one final clarifying point for the record. So this will be brief. I'm going to hand it over to two of our panelists. They were sworn and under oath Wednesday. So I trust that will carry forward today. We don't need to re-swear them.
Yeah, that carries forward. They're still under oath. Appreciate their being sworn before, and the hearing remains as is Wednesday. So testify truthfully.
Excellent. All right. Well, then with that, Claude and Jeff, if you want to go ahead and turn your video on, and then Ryan, if you want to start our presentation. Thank you.
Thank you, Ms. Fulcher. Good morning, commissioners. As you may recall, my name is Claude Boiteau. I'm an asset development engineer representing Civitas Resources. Thank you for the opportunity to provide this brief supplement to the Draco OGDP testimony. I appreciate the Commission's ongoing deliberation as part of the review of the Draco OGDP application. We offer this supplemental information to address Commissioner questions posed during the deliberative stages of the previous OGDP hearing on Wednesday, November 13th. We hope that it may be well received and aid in further deliberations of this best-in-class OGDP. Next slide, please. During our short time with you this morning, we will be addressing an updated community coordination commitment, providing additional details on alternative location number 4, and closing with a few comments on the unique benefits of the proposed Draco surface location. Next slide, please. Extraction is proud of the Draco OGDP and excited about the suite of BMPs that have been brought to bear at this proposed location. Regardless, it is evident to our team that commissioners desire a greater level of community engagement in response to received stakeholder feedback. We have considered this and are willing to commit to 2 additional virtual community call efforts to be deployed in coordination with pre-production development activities. Extraction will collaborate with community leaders to gather stakeholder questions and prepare the informational presentations to be provided prior to the construction and completion operational phases of development. The first community engagement will prioritize the construction and drilling phases of development, while the second community engagement will prioritize completion activities, facility construction, and early production activities. Presentations will be live streamed and recorded, links made available to those recordings on the Draco Development microsite. Extraction will also continue to engage with community members via our dedicated public comment portals. The Commission may recall the stakeholder comment received Wednesday during community testimony, in which the commenter testified that he had contacted Extraction without a response. We have verified that commenter's testimony and found it to be correct. Our team has since contacted Mr. Hemphill and apologized for our oversight. We will continue to engage with Mr. Hemphill until his concerns are addressed. Mr. Hemphill will be reaching out to you again shortly. Next slide. Thank you. We'd also like to note the anticipated upcoming schedule of engagements with the town of Erie. As the Commission will likely recall, the 1041 Vogel process dictated that we engage in collaborative discussions with the town related to multiple development concerns. As part of these discussions, we have committed to continuing this engagement at least quarterly. Based on our projected development schedule, this will provide multiple opportunities to discuss planned development activity with the town staff prior to the commencement of operations. We plan to mirror these engagements with the Erie Land Company. I'd now like to hand the presentation over to Mr. Hannibal to provide a few more details relative to alternative location number 4.
Thank you, Claude, and good morning, Commissioners again. My name is Jeff Annable, Manager Well and Location Permitting. Thank you for allowing us to provide further clarity on the items we presented on Wednesday. I'd like to offer additional details regarding alternative location number 4. As mentioned previously, rezoning the property to heavy industrial would be necessary. It's worth noting that a developer recently spent a decade attempting to rezone and preliminary plat this area for residential use, only to be denied earlier this year. During the proceedings, one trustee remarked that the property still feels and appears unsafe, and despite Town of Erie's staff recommendation of the application, it was denied by a vote of 4-1. Given this history, we anticipate facing similar challenges if we were to propose an oil and gas location adjacent to a historical Superfund site, marked in orange hatch on the map. Furthermore, Erie's regulations require oil and gas operations to maintain a 500-foot setback from surface water bodies. When we apply this buffer, it becomes evident that there's insufficient space to site an oil and gas location, effectively eliminating this option due to relevant local government regulations. These factors make alternative location 4 unavailable for our proposed operations. Next slide. I'd now like to highlight some unique benefits associated with the Draco pad site that would be lost if we were to relocate. Firstly, this location's proximity to 2 electrical substation feeders enables us to utilize dual electric rigs. I would like to underscore the unique nature of this BMP, which allows us for the simultaneous drilling of 2 electric drilling rigs, effectively cutting our cycle time in half for drilling. Additionally, we are again proud to commit to the first in the basin commitment of replacement of 10% of on-site power generation required for completion operations. Secondly, the Draco pad site allows for direct pipeline transport of produced water for recycling operations. Relocating would necessitate truck transportation, resulting in increased traffic and potential road wear. Thirdly, the Draco pad benefits from naturally existing landscape features that effectively shield operational sightlines, minimizing visual impacts on the surrounding area. Lastly, our current plan includes paving County Road 6, a long-term benefit to the local community that would be eliminated if we were to choose an alternative location. These factors collectively underscore the strategic advantages of the Draco pad site, not only for our operations, but also for minimizing community impact and providing tangible local benefits. This, combined with facility design that has essentially eliminated all continuous emission sources with the exception of burning natural gas for process heating, and the partial electrification of completion operations, we firmly believe this OGDP is protective of public health, safety, welfare, the environment, and wildlife resources. This concludes our presentations. Thank you again, Commissioners, for hearing us.
And Chair, that is our slides today. So that concludes our brief presentation. So thank you and Commissioners again for allowing us a few minutes to start the day this morning. That is it for us, but of course we're here for questions.
Commissioner Oath.
Thanks, Mr. Chair. First, I want to say I appreciate your slide on the additional commitments related to community engagement. So thank you very much for that. My question is around the alternative location number 4 component. I think what I gathered from your slide was noting that the town of Erie has a requirement that a oil and gas location be more than there be a setback of 2,000 feet from RBUs, and there are, so kind of confirming that still is not a barrier, but that it seemed like you were noting just that there's a surface water body within 500 feet. Is that correct?
Correct. There's 2 intermittent streams that go along there. If you add that 500-foot buffer onto that, you can kind of see the space that's left over after that.
Okay. Commissioner Oath, if I may, Jeff, you want to be precise too on the setback from those residential homes? She had asked, Commissioner Oath had asked about the 2,000 foot and confirming that. You want to give her an idea of how close those homes are?
Sure. So the setback is 2,000 feet from oil and gas location to the property edge of those homes. I believe our buffer is approximately 2,005 feet as proposed there from that property line, from those property lines to those subdivisions to the south.
I appreciate that. In comparison, the proposed site has 77 homes that are less than 2,000 feet, correct?
It has 5 currently, and only 5 will be there during pre-production operations, all of which have signed informed consents. But yes, during production operations, you are correct with that number.
Great. Okay. I think that's all I have. Mr. Chair, if we have an opportunity, I don't know if Mr. Frank is with us. I'd love to ask him a follow-up question about those surface.
Yeah, I was actually looking at the folks that are signed in to see if I could find Mr. Frank. Would ask Hearings Manager Thomas if Frank is with us, to elevate him so that we potentially can have a question or two for him as well. While we're doing that, though, this panel remains open for questions from commissioners. Commissioner Cross.
Thank you, Mr. Chair. I'm curious if there was any discussions with CDPHE or EPA or anyone else about the Superfund site with respect to alternative location 4.
Mr. Annable.
Yes, thank you, Commissioner Cross. That's an excellent question. No, we hadn't made it that far down the path to have discussions with CDPHE regarding that Superfund site. We just know that it was aware, and as Mr. Frank said, it was remediated by EPA and CDPHE.
Mr. Annable or Mr. Buteau, you mentioned some developer spending 12 years trying to get the parcel rezoned, and you mentioned that it was 4-1 no to a more industrial classification. Was the Superfund part of the consideration of the town of Erie?
Thank you, Commissioner Robbins. That quote I had mentioned was from one of the trustees in mentioning that due to that Superfund site, that property still felt and appears and feels unsafe.
And unsafe meaning unsafe for other development other than what it is right now, or what?
I think unsafe for the residential development that was proposed.
All right. We've got Mr. Frank with us. We're asking questions about the town of Erie. There was some additional presentation, Mr. Frank, from the applicant. There's been some questions. I know you do your due diligence and listen in. I'm going to ask you an open-ended question. What would you like to tell us?
Well, I mean, I don't think that the town has ever formally defined what constitutes a surface body of water. My internal mapping, what I have mapped as our bodies of water, would be lakes, streams, rivers, ditches, things like that. I had never considered a drainage channel to be a surface body of water. And I think if you applied that definition, there's probably very little of the state that would be any reasonable distance from a surface body of water.
Okay, so your testimony would take exception to that setback precluding development on that piece because, in your opinion, as the subject matter expert for the town, that would not be considered a surface body. Is that accurate?
That's not what I had in mind when I read the municipal code. Stating 500 feet from a surface body of water. I mean, any slightly low point would be considered a drainage channel. And calling those intermittent streams, I've lived here 9 years. I don't think I've ever seen flow outside of like the 2013 storm event. But Jeff, maybe you've done better hydrologic characteristics of those two channels.
Mr. Hannibal.
Thank you. Yeah, if you can see from the aerials, there is actually two ponds on that northern channel that flows through there, and water body is indeed defined in the town of Erie's regulations as any surface waters which are contained in or flow in or through the town, which in our interpretation of that would mean even the potential to flow through, which would be a drainage channel or an intermittent stream, which that is a mapped intermittent stream on the hydraulic database.
Anything further, Mr. Frank, on this particular point?
I'll probably have to generate some, do some GIS work with that interpretation. I'll have to speak to our stormwater team on what that definition may entail. There's probably not a lot of the town that's more than 500 feet from water if that's the working definition.
Okay, so that issue's a bit unresolved. A second issue had been this point made by the applicant about the location number 4 and inability to get it to rezone to industrial. It's nearby to the Superfund. Did you have any comments? I'm just trying to flesh out the whole record so that we're hearing from all sides.
We'd met, I want to say 2, perhaps 3 times discussing that with myself as well as other members of town staff from, say, the planning department, et cetera. And as I recall, last August, where we'd left off was, arrange a pre-application meeting so we can discuss what will be entailed in the process, what the town would like to see. And that pre-application meeting was never requested. So it's the view of the town that process never formally started by any measurable stand,
Okay, fair enough. Commissioner Oath.
Thank you, Mr. Chair. Like you, just trying to get a sense of the lay of the land here. So back on the surface water bodies, again, noting that there may be some ambiguity here on whether or not there are water bodies that meet the town's definition within the town's setback. I don't know how the setback works in the town's code. So let's say they do qualify. Is that a hard setback? Do you all consider variances, waivers in terms of looking at the 2 locations and kind of a policy determination from the town on whether or not, which location has less impact? Can you opine on?
I apologize. My internet connection dropped out there just momentarily. Last I heard was, is that a hard setback?
Yeah. So that's the first part of my question, really, and probably the heart of my question of, is that a hard setback, or does the town have processes to where you might still rezone within, even if a location would be within 500 feet of a surface water body? Like, is that even an option, or is that just like a black and white?
There's 2 separate pieces. One is the zoning, and that has nothing to do with the presence of bodies of water or used wells or anything like that. That would just be the characteristics of the land, adjacent uses, etc. The setback from bodies of water is specific to oil and gas location permitting within the town. And I don't believe there are any off ramps. If there's a used domestic water well or a pond, I believe there'd be a strict 500-foot setback from those locations.
Commissioner Messner?
Thanks, Mr. Frank. Just to confirm a couple of things. I think in your testimony on Wednesday, you indicated that currently that's zoned agricultural.
Yeah, I think the technical. I looked it up, in the zoning maps, and it's called agricultural residential, which means essentially farmland with a house every 5 acres or something.
Mm-hmm. Okay, and I think what I'm hearing you say is the town is defining surface water without the utilization of the term intermittent stream.
I'll have to look into that and talk to our stormwater folks specifically. And if given that seems ambiguous, we'll probably have to revise our code to be more direct and reflective of our intentions.
Okay.
But I will say in the lengthy discussions we had about alternative location number 4, the presence of water was never brought up, and it didn't seem to prevent plans from progressing until presumably yesterday.
Okay. And if I recollect your testimony from Wednesday, you also indicated that, in your opinion, there's some compatibility with oil and gas operations with adjacent uses like landfills, and that compatibility with heavy industry and landfills seems appropriate.
Yeah, the landfills have oil and gas pads already adjacent to them, and that parcel has multiple oil and gas pads currently in production. 2 operated by Civitas, and I believe 3 others operated by KP Kaufman.
And the decision on the denial of the residential development that was proposed was specifically because the zoning was proposed to be upgraded to what it currently is, which is, I think you said, agricultural residential. Let's just say that's 1 house per 5 acres or more, to something significantly more dense, which may not be compatible with the surrounding uses, i.e. landfills. Was that the determination that was made?
I don't want to speak for our town council members, but to summarize, there were concerns about the previous entombment of solvents that's been cleaned up, and how permanent that situation is, as well as the active land use next door, landfill next door, and the 5 oil and gas pads in immediate proximity.
Okay. Also, just trying to better clarify the lay of the land there. So I appreciate your testimony and your willingness to be there.
2 of the oil and gas pads would have been in the center of that neighborhood, not on the periphery, with houses on all 4 sides.
Okay. Thank you.
Hold on just a sec. I'm going to recognize you in just a bit, Ms. Fulcher, so you can lower your hand. We'll get to you. Let's finish up with questions first. Commissioner Ackerman.
Thank you, Mr. Chair. I appreciate that. And just a further clarification to Mr. Frank on the point that we were just discussing with the application upgrade to residential being unsuccessful after what seems to have been a lengthy. In general, are there different considerations in determining something viable for residential development and upgrading to that status as opposed to downgrading a status to industrial?
I'm not certain. That's a bit out of my wheelhouse, but I would presume that hundreds of homes versus not permanently occupied by humans. It's not like we're talking about office buildings or convenience stores. You'd have personnel occasionally visiting a site for maintenance and inspection rather than working 8 hours a day there. So I would imagine that would play into a decision on what appropriate zoning is.
Thanks. That's all, Mr. Chair.
Commissioner Cross.
Thank you, Mr. Chair. And I don't know if this is a better question for Mr. Frank or perhaps the operator here. In the map for alternative 4, it is showing the two, I believe the operator called them intermittent streams, the drainage there. The one directly to the north of where the pad would be in it seems to have, is that a pond? Is that what is that?
So that whole area, that's the former Newshauer landfill, which was extensively remediated and is currently undergoing the final cap and placement, the evapotranspirative covering, and there won't be any standing water in that area, certainly. And the engineering on that was like sub-inch horizontally and sub-foot vertically. It's about the most ridiculous 600-page site plan engineering report I've ever personally seen.
Okay, I just wanted to confirm that as we were talking about the different.
The whole point is to prevent standing water and infiltration of meteoric waters down into whatever remaining contaminants might exist in that draw.
Okay, thank you.
Further questions for the panel or for Mr. Frank? Ms. Fulcher, you're recognized.
Thank you very much, Chair. I appreciate just the opportunity to clarify a couple of things for the record. The information that we wanted to draw your attention to with respect to this water body issue and the fact that we've got surface water bodies, and these are defined and qualify as waters of the state under your regulations. That is not new information. That is not information that we emphasized Wednesday because there are other disadvantages with AL4, as we noted in the alternative location analysis that was submitted with this application, including, again, the issue with the Superfund site. And I think the applicant would share those same concerns with potentially locating a pad on what was the Superfund site, but also what we know to be true right now today about the zoning, not what we speculate could be true years down the road. But in addition to those disadvantages, the water issue was noted in the plat that was provided to the staff as part of our alternative location analysis back when the application was submitted. So I just wanted to draw out that information was included. We just wanted to emphasize it today for clarification to the record. And so that is all I have for you.
All right, thank you very much. Any final questions? Mr. Frank, I see you've unmuted. Did you have something?
I'd just like to say one final thing is that the statements that there won't be any occupied homes within 2,000 feet of Draco during pre-production, that is only true if this commission chooses to add a condition of approval that pre-production ends by mid-October 2027.
Yeah, no, I appreciate that. That was made fairly accurately in the record. I think there still is this sort of 7-month sort of something time frame, but I think the commissioners are aware of that point. Commissioner Oath, did you have a question on that point or something else? I saw you raised your hand.
Something else. Sorry, Mr. Chair. I guess now I have a follow-up question for CDPHE on this Superfund site.
Let's bring Ms. Sorensen back to the panel.
Ms. Sorensen's been elevated, but she's having camera issues, so she asked for 1 moment, please.
Here, give us just a sec. Let's take our time here. I see she's trying. There we go.
Okay,
Great.
sorry about that.
Let's have Commissioner Oath re-ask her question or state her question.
Thank you, Mr. Chair. Thanks, Ms. Sorensen, for coming back up. There's just been some additional testimony here about, potential concerns with this location due to a Superfund site. And I do note that based on Commissioner Cross's questions that you all have not had a chance to talk about this with the operator, but could you share what does CDPHE have thoughts on this Superfund site and compatibility or concerns with locating an oil and gas location nearby?
So I guess my question is, what Superfund site is being referred to here? Which specific NPL site are we looking at?
I think I can clarify. So it is not a Superfund site. There was EPA involvement. However, the landowner, in conjunction with CDPH&E, have successfully remediated that site, and it does not qualify for Superfund status. But it is the drainage immediately to the north of alternative location number 4.
Okay, thanks, Mr. Frank. Mr. Annable, you're the one who characterized it as a Superfund site. Do you desire to weigh in on this point?
Thank you, Commissioner Robbins, or Chair Robbins. Yes, so it is a historical Superfund site. It is listed as a Superfund site on the EPA website. The Niehauser landfill is listed, and I can send a link to that if necessary.
Ms. Sorensen, are you ready to provide some perspective given those two narratives?
Okay, I assume this is a Superfund alternative approach site. So there are two different classifications of EPA Superfund sites. There is a Superfund NPL, or a National Priorities List site, and then there is an SAA, or a Superfund alternative approach site. And I assume this is under the SAA category. All SAA sites are actually are usually run by as part of the CERCLA programs in there, and so that's basically a different enforcement approach. So that would be under a particular CDPHE cleanup thing. We typically do not think of those sites as Superfund sites, which is where the confusion comes in. We're typically looking at NPL sites, or National Priorities List sites. The most recent we saw actually involving Civitas was the proximity to the Lowry landfill, which is an NPL site. In terms of proximities to a site like that, it's not something that can be blanket answered, because it really is case by case on what those sites are, what the type of contamination was, what the continued contamination is, what the expected cleanup time is, and kind of what the extent of that is. So CDPHE can't answer that question for this specific site, for this specific ALA location. We did not look at that particular cleanup site simply because once something goes through the ALA process, they have settled upon a primary location to go for, and it passes completeness, and that is the site that we evaluate in our consultations. So if that site is going to be, if it would be changed to that location, we would have to reevaluate, of course, to look at that. And that, I think, would kind of push the reset button on a lot of the process in probably a very complex manner. But yeah, if you would like us to look into that, please let us know, and we can certainly investigate.
No, I appreciate the answer, and I think it does get to one of the fundamental pieces of how we do our business, which is we have rules that require alternative locations to be assessed under certain circumstances, but ultimately it is the up to the operator to move forward with a actual location, and that's the one we analyze for whether approval or not. Okay. Further questions for the panel? Commissioner Messner?
Thanks, Mr. Chair. I don't have a question for the panel. I wonder if the commission would consider, however, if we are moving into deliberations after this, to close the record prior to deliberations so that we don't have a glut of additional information and kind of he said, she said as we work through our deliberative process, because I think at this point the record's been set, and I think it might be cleaner in our deliberative process to not continue to bring in additional information in the middle of deliberations, but that's just a thought.
Yeah. Any other just final ask for questions? Seeing none, I would close the record. The panel can go away.
Thank
Bring
you,
back.
Commissioners.
Mr. Chair, if I may.
Go ahead,
We
Angie.
typically have a motion to close the record, motion second, and vote. So I would suggest that process.
So moved.
Second.
Everybody in favor of closing the record indicate by saying aye. Aye.
Aye.
Any opposed? Record's closed. We're moved to deliberations. Commissioner Ackerman?
Thank you, Mr. Chair. And I really appreciate the extensive discussion, the public input that we've received on this issue. I appreciate the engagement of the public, the engagement of the town and the counties that are involved, as well as the citizenry nearby. To me, this application is very challenging. On one hand, it includes many best-in-class practices that we often encourage. And on the other, there are certainly difficult and complicated jurisdictional issues and one administrative issue that I'll touch on. As far as the multi-jurisdictional issues, it's really abundantly clear that the preponderance, if not the entirety of the potentially impacted residents and the other homeowners who have weighed in are not in favor of this application. It's not uncommon for nearby homeowners to voice opposition when a new pad is proposed, even if, as in this case, at least in Weld County, residents should reasonably expect the potential for further oil and gas development when choosing to live in the midst of already existing oil and gas exploration and production. And as has been noted by the operator, this pad is being proposed for directly adjacent to an existing oil and gas gathering facility. And it's been noted by many of the testimonies that this location is proposed in an area with significant historic and ongoing oil and gas production. And I generally come from the perspective of giving significant deference to local governments with regard to the use of the surface within their jurisdiction, including best placement for oil and gas developments, as in my opinion, local governments are the ones most poised to determine appropriate surface uses and are the primary government officials most charged with implementing the will of their specific residents, generally preferentially to the will of the state as a whole, which is a component of our focus. But this situation is complicated by this project surface location being in Weld County, which as has been noted, is a county that has an extensive oil and gas exploration and development program, and will drill below ground to reach under Boulder County subsurface for approximately half the length of the wells. Boulder County, conversely, is a county that's vocally and officially expressed that it does not support nor seek to facilitate high intensity oil and gas development. And as such, it's somewhat reasonable for residents in Boulder County to assume lower potential for oil and gas exploration, particularly as proximity to the border of Weld County decreases. And although I would note that obviously all development in Boulder County will be subsurface and will very likely be undetectable to those homeowners in Boulder County. And adding perhaps the most amount of jurisdictional complexity, the great preponderance of the impacted nearby surface homeowners are within the jurisdictional boundaries of the town of Erie, since the proposed surface location is at the edge of a narrow peninsula of Weld County and is nearly surrounded by the town of Erie. And because that proposed surface location isn't within Erie's jurisdiction, Erie doesn't have the same standing under our rules as does the relevant local government, which is Weld County. But because that location is within 2,000 feet of the town of Erie, the town does have standing as a proximate local government. And that standing gives Erie significant opportunity for input into both Weld County's process and the ECMC process. But to be clear, that standing does not provide an opportunity for the town of Erie to deny this development or impose conditions of approval on its own, as it would be able to do if it was the relevant local government. And this creates a difficult anomaly under our rules in which essentially the entirety of impacted residents falls within the proximate local government rather than the relevant local government where it usually falls. As such, to me, this application is a poignant illustration of the issues with projects that have multi-jurisdictional implications. And I appreciate Commissioner Messner's suggestion, particularly with regard to his local government background, that neighboring local governments active in oil and gas development would strongly benefit from engaging in pertinent good neighbor agreement discussions in order to outline how jurisdictions will address interjurisdictional impacts. As Senate Bill 19181 purposefully gave significant opportunity for local governments to better control their own destiny with regard to the use of land surfaces for oil and gas development. I agree with this sentiment and would encourage continued discussion of agreements between adjacent jurisdictions to address these issues. And I would note for the public, however, that while I think interjurisdictional agreements would be prudent, that ECMC does not have any authority to direct the establishment nor to control the content of any such agreements. And that's solely the purview of your local governments. So because of the interjurisdictionality and the complexity associated with that, I think it's important to examine and give significant weight to the positions expressed by each of the affected jurisdictions. In brief, Weld County, which again is the relevant local government due to that small portion of Weld County being the surface location proposed. Obviously, they support this development, they support the proposed location, and they note in the application that they note that the application has met the Weld County requirements for oil and gas surface use. Again, noting that they are focused on the surface. The town of Erie, which is the proximate local government, worked on this issue in significant tandem with Southern Land Company and ensured its citizens that Southern Land Company's negotiations were successful and that the company is a great friend to the residents of Erie. The town and Southern Land Company's negotiation with the operator resulted in several additional significant mutually agreed upon conditions outlined in detail by the town of Erie and Southern Land Company, but in summary are a 36-month timing limit from the date of approval, survey inspection and monitoring of certain P&A wells, and some transportation and access agreements. And the operators agreed to all of these conditions. If we go down that road, I'm certainly interested in our Attorney General counsel on ECMC inclusion of any or all of those conditions of approval in a potential ECMC permit, should we go that direction. Erie noted its support of the negotiated terms between the operator and Southern Land Company, and Erie also noted that it couldn't cite any specific cause for denial other than recognizing nearby residents' opposition to the project. And in short, the Southern Land Company recognized and thanked Extraction for negotiating in good faith and supports the path forward resulting from that negotiation. Boulder County didn't provide any written comment, but Commissioner Ashley Stoltzman, chair of the Boulder County Commission, testified before us and raised two specific issues. One issue was that wells drilled under Boulder County potentially threaten existing wells on Boulder County open space, and she specifically asked for certain actions to shore up the Prince 1 well. She also expressed concerns about cumulative impacts and threat to air quality and the climate. She stated that Boulder County supports and endorses the comments that were submitted by the town of Erie and Lafayette, and she asked ECMC to use the mitigation hierarchy looking at why we are not relocating, downsizing, or denying this project. As far as the merits of the application and arguments made, it's clear that this application includes many best-in-class practices, as detailed in the documentation and the operator's testimony. and reiterated in pretty significant detail by Commissioner Cross during the previous hearing, so I won't restate that. I think the operator has generally done very good technical work on this application. And notably, as per surface disturbance and emissions, this project is expected to result in a net decrease on both counts, both surface disturbance and emissions. And that point is particularly pertinent as Commissioner Stoltzman and various residents have raised concerns about protecting air quality. Before I kind of wrap up my point, I wanted to state that a number of comments, both written and verbal, have been made about the ECMC mission. It's been pointed out a number of times that our statutory mandate is to regulate the development of oil and gas in Colorado in protection of public health, safety, welfare, the environment, and wildlife resources. I want to assure the public that we are indeed well aware of this mandate and deeply understand its direction and its intent. It's important to understand that it's not the intent of the statute to prohibit oil and gas development in Colorado under that broad direction, but rather to ensure that appropriate rules are in place that best protect Colorado in the course of fulfilling the mandate to regulate such development, as that same statute also requires that we regulate in a manner that reflects a necessary and reasonable approach to imposing conditions on operators. So to me, the situation as it sits now is that the applicant, the impacted land company, the relevant local government, Weld County, the proximate local government, the town of Erie, have all come to agreement on a plan using the proposed location. Despite the relevant local government, despite being the relevant local government due to the proposed surface location, the only part of this development that impacts Weld County is that proposed location with downholes and ambient issues reaching into Erie and to a small extent on the west end of unincorporated, or the east end of unincorporated Boulder County. Impacted residents, some of whom are very nearby the proposed location, are all residents of Erie, the great preponderance of which remain opposed to this development. And it's clear that a considerable number of future homes and a school and a playground are all at least planned in the vicinity, many of which will fall within 2,000 feet of the proposed location. These were development plans that were well known and underway at the time of this application. And I understand that potential homeowners will willfully purchase homes with that pad already in place. But the question that I ask myself laying in bed at night is, does that put us in a position where we have really adequately minimized the impact to those future homes and other potential developments? Planned developments, I should say. As I noted, Erie worked with the developer to come to an agreement, although in testimony, Mr. Frank noted that Erie is working from a difficult position, recognizing the point that I've keyed on a number of times. While Erie only has consulting status as a proximate local government, Erie's residents are the primary impacted citizens. I've said a number of times in the past that lack of public comment, a significant public comment on an OGDP generally indicates no significant opposition. Ergo, to me, the opposite is true. There is significant public opposition to this project. So where does that leave us? And to me, the bottom line is I believe the significant public consternation associated with this application is warranted. The primary consternation I have with this application in its current form is because the great preponderance of the impact will be imposed upon a citizenry who lack the generally afforded status of their local government being the relevant local government, and therefore the permitting entity under our rules. And specifically, I have a concern to the point that we've talked about today, that there has been a significant misunderstanding about the potential availability of alternative location analysis location number 4. Extraction stated in the ALA narrative that they believe this location could be protective, but that it was removed from consideration due to the inability to permit under existing zoning. The ALA narrative specifically states that there's no clear line of sight with the town to use this already heavily industrialized location. The testimony of the town, as I heard it, was that this is not the case. Erie testified that a process for consideration of ALA location number 4 was suggested by the town, but that process was never initiated. So given this sequence, it's not clear to me at this point if ALA location number 4 was correctly and appropriately considered, and whether this location would indeed be protective as suggested by extraction in the ALA. It's, again, already a significantly industrialized area that's been formally deemed not suitable for residential use. It's got existing oil and gas use. But to me, and very importantly, it lies within the jurisdiction of the town of Erie, where the great preponderance of the impacted residents live. And as the primary impacted jurisdiction, increasing Erie control over the surface location of this development that heavily impacts Erie residents is more appropriate, as it would provide a more empowered approach for the town to be able to address the desires of the town and its residents, again, who are the most impacted public. If it is reasonably available, it makes sense to me and seems necessary and reasonable to ask the operator to work further with the town on ALA location number 4 in order to appropriately apply the mitigation hierarchy, seeking first to avoid the impact of the heavily populated and soon to be even more heavily populated residential area in favor of an area currently in heavy industrial use, which to me appears from testimony to have a potential avenue for use contrary to the submitted ALA narrative. So all that to say, Mr. Chair, my suggestion would be to thank Extraction for a lot of work that they've done. I do very much appreciate the best-in-class practices that are being proposed here. I think being able to propose those same practices in a location that's more favorable to the most impacted public and most impacted local government is appropriate. And so if Erie feels that there is indeed a line of sight for the use of that location, my preference would be to stay this application and ask for further work on that front to ensure we've appropriately employed the mitigation hierarchy. I appreciate the opportunity to comment. Thanks, Mr. Chair.
Thank you for the comments, Commissioner Ackerman. Commissioner Oath?
Thank you, Mr. Chair. Like Commissioner Ackerman, I would echo that this is a very challenging application. I have actually appreciated the additional time over these last couple of days. I spent a lot of time thinking about this, grounding my thoughts in our rules and in the act, and even going back and re-listening to a good part of the testimony that we heard on Wednesday. And I think that's really important. You know, what I see as, you know, the guiding principles and requirements in our rules and in the act are, you know, starting with the act indicating that the commission shall regulate oil and gas operations in a reasonable manner to protect and minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources. Our rules mimic that very much, which makes sense. In Rule 301, it says, you know, the commission will approve operations only if they protect and minimize adverse impacts. Rule 307, with respect to denial, indicates that if the commission determines that an OGDP does not minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources, or fails to meet the requirements of our rules, the commission may deny the OGDP. And then, so in each of those cases, it's about minimize adverse impacts. But minimize adverse impacts is defined in the Act to mean that to the extent necessary and reasonable, that we have to first A, avoid adverse impacts from oil and gas, and B, then minimize and mitigate the extent and severity of those impacts that cannot be avoided. Again, looking at the definitions of avoid adverse impacts, minimize adverse impacts in our rules, same dynamic and dichotomy jumps out to me as being very clear. Our statement of basis and purpose even says that the term minimize adverse impact is as defined in the statute, sets forth the mitigation hierarchy by directing the commission to first avoid impacts, then seek to minimize unavoidable impacts, and finally to mitigate those unavoidable and adverse impacts. You know, so referring to unavoidable adverse impacts, that's defined in our rules to speak to indicating that the application of the alternative location selection is the method is the method designed to minimize adverse impact. And further, our statement of basis and purpose says this as well, that the use of alternative location assessment is the primary means of achieving avoidance of adverse impacts. And so grounding my analysis of this application in what I see as really clear direction, both from the Act and the rules, I see, you know, that the proposed location is within 2,000 feet of 5 existing homes and 72 planned homes that are very, very clearly going to be occupied by residents. There is a park within 2,000 feet, a trail, and we heard some conflicting and unclear testimony about a school, but potentially also a school, but even if ultimately the school is not realized in the future, the other factors that I just noted will be are and will be in place. So that leads me to, noting that I think, the operator does have the burden to demonstrate that it's complied with the mitigation hierarchy. And I don't think I'm not convinced that has occurred here. Absolutely that the measures proposed in this application are in many ways best in class, as have noted. I don't need to reiterate them. I agree, Commissioner Cross, you did a really thorough job of indicating all of those. But to me, those are measures that go towards minimizing the impacts of the operation, but doesn't convince me that I haven't been convinced that those impacts are unavoidable. And that's because we don't know at this point whether or not alternative location number 4 is viable. We have testimony from the town of Erie that they met 3 times to discuss this location. And while no current locations within the town are zoned heavy industrial, and I note the applicant's indication that the town does not have guidance for how to put together an application to rezone to heavy industrial. The town did not indicate either during those discussions nor during this testimony that it was not possible or would not be considered, but rather invited the operator during those discussions to schedule the pre-application meeting with the planning department to discuss next steps. And as I understand the testimony, the operator chose not to pursue this avenue further. Further, we've heard testimony from the town that there is existing oil and gas uses on this parcel with 5 existing pads, as well as what I see as several other active and inactive landfills that, as was testified, would be consistent with heavy industrial activity. And that's further evidenced in my mind, actually, by the town's denial of an application to rezone the area to residential. Finding it not fit for residential use does not mean that it would not be fit for heavy industrial use. The testimony from the operator about why they did not pursue this location further was that they did not see, quote unquote, a clear pathway to rezoning it to heavy industrial. But in my mind, that is quite different than not having a viable pathway to rezoning. Rezoning may be difficult. It may be uncertain. I recognize that, but that's not the standard here. I think we need to be, it needs to be clear that the operator has demonstrated that the impacts here are unavoidable. I recognize that with alternative location number 4, as the operator noted today, they feel like there are some potential additional downsides to that. They noted that there are 84 RBUs that are I guess within some proximity, but are outside of that 2,000 feet of the setback. And that does give me some pause, though. I think it was a fair point the operator made that those homes would be in place during pre-production activities, whereas in the proposed location, they have come to an agreement with Southern Land Company that they would not, that the pre-production operations would presumably conclude before occupancy of the additional 72 homes where informed consent has not been provided. So I do recognize that point. With respect to the other environmental concerns noted for this alternative location, there's a good amount of uncertainty about that. There was this testimony about the surface water setback. I think based on the testimony that we heard from the town, it remains unclear to me about whether or not that would be a barrier for this location, and similarly with respect to the SAA or potential prior Superfund site that has been remediated. I do appreciate CDPHE's consultation and their testimony. In my mind, that testimony goes to helping inform us from their subject matter expertise about whether the proposed BMPs for the proposed location adequately minimize and mitigate the impacts. And I very much appreciate their perspective on that and find that very helpful. But in my mind, this commission can only get to the question of whether or not the impacts for a proposed location adequately minimize and mitigated if the operator has first demonstrated that the impacts are unavoidable. I'm not going to comment here, I think, or make a finding here about whether or not the application adequately minimizes or mitigates those impacts, because as I said, I believe that the operator first needs to show that the impacts are unavoidable. And I do not believe that, I don't feel comfortable that that demonstration has been made at this point. So that is where I am. I could be supportive, as Commissioner Ackerman suggested, of a stay to allow the operator to pursue additional conversations with the town and, come back here and provide us additional information about whether or not location number 4 is a viable location. If it is not, I think we could then consider this application being, convinced that it's unavoidable and consider whether or not the impacts have been adequately minimized and mitigated.
Thank you, Commissioner Oath. Commissioner Messner.
Chair Robbins, I would like to take a little bit of time to, further flesh out my deliberations, as I did feel a little rushed on Wednesday, but I don't want to do that before giving you the opportunity to provide initial deliberations. So I'll wait until after you're complete.
Okay. I'm conflicted a bit, and I think it gets to sort of a fundamental issue that we have with regard to how we evaluate proposals before us. And it gets to this situation that our rules call for alternative locations to be looked at under certain circumstances. But it also gets to the situation where the operator has to move forward with a proposed location. And in this instance, we have the operator that has moved forward with a proposed location that I believe does a good job of not only avoiding, but then for sure minimizing and mitigating. But I'm also conflicted in that I don't know, and I agree with Commissioner Oath and Commissioner Ackerman, that I think that the best step is that there needs to be further analysis of the alternative 4 location, because we've not done the operator by our rules was not required to do as full of an analysis of whether that location could have been more avoidable, for to use the term, than the location that they move forward with. I think this is further amplified by the fact of the jurisdictional concerns that Commissioner Ackerman raised, where the impacts are felt by the proximate local government as opposed to the relevant local government. That's the town of Erie, as opposed to the folks in Weld County who are the relevant local government. I also have concerns that, and I'm kind of across the board here, but I have concerns that, as Commissioner Ackerman noted in his comments, that we have, quote, significant public consternation in this instance. Well, I don't know that significant public consternation, and just to be honest here, is a relevant rule. It needs to be public consternation that ticks and dings specific rules and regulations. And I get it. I understand that there are folks that, this is a little bit like the matter involving Lowry, where we had significant public consternation, but at the end of the day, did it actually impact negative findings on our rules? And we found that it didn't. I tend to see the same thing here. And that's not to minimize or mitigate or devalue folks coming in and talking to us. Having said all that, I would be in favor of staying and requiring a additional analysis on alternative 4, And I would hope that the town of Erie is impressed by the Energy and Carbon Management Commission's decision in that regard so that they thoroughly evaluate and understand that they're given an opportunity to become the relevant local government and to operate in a significant manner in that regard. And if that were not to come to fruition, then I feel comfortable that the current location is ultimately approvable. I just would like to see the other one analyzed a bit further to determine if we have accurately created jurisdictional pieces for the town of Erie and its citizens. Commissioner Messner?
Thank you, Mr. Chair. And, Commissioners Cross, Oath, Ackerman, and Robbins, really appreciate your perspectives and your points of view. As always, I appreciate your knowledge, your judgment, and how you apply that in our processes. And, we don't always have the same point of view or come from the same perspectives, but do know that I appreciate your perspectives on these. I just wanted to kind of reiterate and flesh out where I was, and this is I appreciate being able to listen to the other commissioners and gaining their perspective as well, because I think it is important. But as I look at this is a very difficult application, and I do acknowledge and appreciate the work that the applicant has done on this, and the best-in-class BMPs that are being proposed, because they really are the best-in-class BMPs, and I appreciate that. But I do find that the mitigation hierarchy was not properly followed. I do note that on page 72, the statement of basis and purpose, the term is defined in the statute, sets forth the mitigation hierarchy by directing the commission to first avoid impacts, then seek to minimize unavoidable impacts, and finally to mitigate those unavoidable and adverse impacts. Commissioner Oath provided the definition of avoid adverse impacts, which I think is important. The statement of basis and purpose in page 79 highlights that Senate Bill 19-181 amended the definition of minimize adverse impacts, which directs the commission to avoid adverse impacts from oil and gas operations, wherever that statutory term is used. The alternative location analysis is the commission's primary and best tool to avoid adverse impact, because the most effective way to avoid adverse impact is through siting decisions. I think Commissioner Oath highlighted where minimize adverse impacts is used both in the definition in the rules as well as in statute 3460-103.5. I won't reread that. But I do think that there are some problems with the mitigation hierarchy not being followed and not being avoided first. And these are the reasons why. Alternative 4 is available, and the applicant did not meet its burden to indicate why it's not available. Twice now, Erie has testified that it is available and possible. It's zoned agricultural, has existing oil and gas locations, has proximity to landfills, which has been determined in testimony to be compatible with heavy industrial uses. It's not within 2,000 feet of homes, schools, or parks. Statement of basis and purpose, page 77, indicates the purpose of the alternative location analysis is to create a tool for the commission, its staff, and the operator to use to identify the best location to avoid adverse impacts to public health, safety, welfare, and the environment and wildlife resources. Statement of basis and purpose also indicates on page 79 that Rule 304B2B Romanet I and Romanet 1, Romanet 2 are intended to work in concert with Rule 604 to ensure that operators and the commission staff engage in a robust analysis to determine whether there is a viable alternative location that would avoid potential adverse impacts on residents and schools within 2,000 feet of the working pad surface. I find that the proposed location is not protective. Statement of basis and purpose on page 219. Evidence in the administrative record clearly supports the conclusion that there are health impacts that are highly likely to be attributable as a result of proximity to oil and gas development. The body of peer-reviewed scientific literature documenting potential health impacts that are likely attributable to proximity to oil and gas development is robust and growing. Peer-reviewed studies have identified a range of different adverse health outcomes with a high degree of statistical likelihoods, and that those adverse health outcomes are likely to occur at a variety of distances from oil and gas operations. Statement of basis and purpose, page 221. Substantial evidence in the record demonstrates that a 2,000-foot distance would avoid a significant number of impacts and is therefore necessary, particularly for school facilities and childcare centers. The CDPHE goes on to say the CDPHE study supports the Commission's cautious approach to protecting people's health and provides evidence that the Commission's choice of a 2,000-foot setback is appropriate. The Commission also chose the 2,000-foot setback because of the statutory mandate to protect and minimize adverse impacts to public welfare and public safety. That's CRS 3460-106 2.5A. And finally, in the statement of basis and purpose, page 219, based on substantial evidence in the administrative record, the Commission determined that a 2,000-foot distance was necessary and reasonable to avoid, minimize, and mitigate potential impacts to public health and welfare. The proposed site has proximity to homes, schools, outdoor concentration areas, and is a problem whether they are built today or not, in my opinion. There are 77 building units, one potential school, and outdoor recreation concentration areas, all within 2,000 feet of this location. I acknowledge the uncertainty around the school, but I still think it has to be considered. It could not have been clearer that what was being proposed in this location when the applicant submitted the application, that these things were being contemplated. The school site is in the town's comprehensive plan. There was 7 years of review processes for the housing development. There's a state school requirement for locating the school in this area. These were all known. They all need to be considered, and they all need to be addressed. These are reasonably foreseeable known receptors, and the 2,000-foot setback is not just for pre-production operations, but rather for oil and gas operations for the lifetime of the well. Statement of basis and purpose, page 70. The Commission recognizes that understanding cumulative impacts requires information about past, present, and reasonably foreseeable future impacts, and that legacy plugged and abandoned wells may contribute to cumulative impacts to subsurface resources such as groundwater. This was discussed during mission change, the concern with the local government siting locations in a way that could impact residents of different jurisdictions. We are seeing it play out here. I think Commissioner Ackerman highlighted that very clearly. I will note that on the statement of basis and purpose, page 60, because the impacts of oil and gas operations do not necessarily respect jurisdictional boundaries, the Commission determined that it is necessary for local governments in close proximity to a proposed oil and gas location to have a defined role in state permitting decisions. And my other point here in this application is that Rule 304 C19 Cumulative Impacts Plan did not address to an adequate level the site-specific measures on how this application evaluated and addressed cumulative impacts, particularly with the quantitative and qualitative evaluation around public health impacts as identified in the Form 2B, but how it should be addressed should be in the cumulative impacts plan as required by Rule 304 C19. Statement of basis and purpose, page 62. Additionally, operators must submit a cumulative impacts plan as an attachment to a Form 2A pursuant to Rule 304 C19, in which operators must demonstrate their plans to address cumulative impacts of each proposed oil and gas location by avoiding, minimizing, and mitigating those impacts. The Commission intends for its staff to critically evaluate the information submitted in both the Form 2B pursuant to Rule 303 through A5 and in the cumulative impacts plan pursuant to Rule 304 C19 to verify that operators are making robust and thorough efforts to meaningfully address cumulative impacts to the relevant resources. I think that I appreciate CDPHE's testimony and apologize if I hit a nerve. I have to determine what information I use, and in order to determine how I'm going to use it, I used the word credible. I think that was probably an inappropriate term, and so I apologize for that. I'll revise that to say that as Ms. Sorensen provided testimony today, CDPHE does not make recommendations for approval, but rather provides information, as indicated again in Commissioner Oath's deliberations. Their consultation provides recommendations for how the applicant could minimize or mitigate potential impacts, but doesn't address the siting considerations for avoidance because they are providing that consultation on the proposed site and the application, and that we are required to provide the mitigation hierarchy in our review that first requires avoidance. So that further clarifies and gives me an opportunity to provide on the record the where in the rules in the statement of basis and purpose I'm making my determination. I do have problems with the proposed location. There is the possibility, I think, for further work on an alternative location within the jurisdiction of Erie. If I was asked to vote on this today, whether to approve or deny, my vote would be to deny the application for the reasons I've stated. But I am not opposed to staying the application to allow the time of Erie to fully flesh out the potential path for permitting associated with alternative 4. And so that's where I'm at, Mr. Chair.
Thanks for the deliberative comments. Commissioner Cross.
Thank you, Mr. Chair, and thank you to my fellow commissioners for their thoughts today. I also want to say thank you again to the public. We received additional comments, which I know I, for one, have read and forwarded on to our hearings manager so they can be included in the record as well. And I want to make sure that the public is aware that we do read those. We do appreciate what you're saying. And as Chair Robbins noted, I don't know that any of the concerns specifically addressed the rules. And that's why I spent a lot of time on Wednesday to try and make sure that many of the issues that were raised in written public comment and public comment provided on Wednesday and public comment provided over the last day and a half and public comment provided during the 511 hearing. I wanted to make sure that I touched on a lot of those issues in questioning with the operator to make sure that the public is aware that we do try and make sure that these concerns are addressed. And I do believe they are here. I do, as has been noted by Commissioner Ackerman, by Commissioner Messner today, these really are best-in-class BMPs being provided here. I have no concern with the length of the laterals. I have no concern with the potentially hitting offsets. There are numerous different ways they try and avoid this. They're doing 3-phase takeaway, which as Liaison Sorensen noted today, that's one of the biggest ways that you can avoid any production impacts. I will say, when it comes to the alternative 4, I understand and I appreciate my fellow commissioners' thoughts on this. I took this as a little bit differently because, in my opinion, I think both the difficulties with permitting as well as the difficulties with the Superfund site, to me, I thought were valid reasons to eliminate option 4. And I understand and appreciate my fellow commissioners wanting more information on that, and I'm happy to get more information on that. I will say that I think my biggest concern with going down that path is that, as was noted by the operator, this can sometimes take years to even get to the zoning, let alone the permitting process. And I think by that point in time, the proposed location, which I do believe avoids to the extent possible, and what it can't avoid does sufficiently minimize and mitigate any adverse impacts, will no longer be available because of the houses being built by that time, the agreements between the Southern Land Company and Erie and the operator no longer being available. So I do have some concerns with that. And so I did not have an issue with the operator choosing to move forward with the proposed alternative as opposed to alternative 4 because of that timeline basis as well. And then potentially not having any sites that would be available and feasible. I do think that in addition to, and I appreciate Mr. Frank providing information on saying that it's not impossible for it to get done. I don't know that I heard testimony from those that would be in charge of the actual permitting within the town of Erie saying that this can be done in time, that it would be done, that it would be feasible. Instead, we had Mr. Frank saying that it could be possible. And so I too would be fine with additional information being, additional time being taken to understand whether it could happen. I think it also would be important to know what a timeline like this would call for. And I think during that time, I think it would also be important to understand if we could even have this operator drill under and through the Superfund site that would be adjacent to an alternative 4 location. One of the things that stuck out to me is there was obviously a lot of concern about drilling near the Superfund site at Lowry. As Ms. Sorensen indicated, there are obviously differences, and those differences were not evaluated by CDPHE as they look at the proposed location and not the alternative locations. But I think it would be interesting to know that, because obviously there was, as Chair Robbins noted, significant consternation with the fact that laterals may go even near the Superfund site at Lowry. And this would be a much different situation where here it would not just be laterals going near it, but drilling occurring adjacent to, directly underneath and through the Superfund site before the laterals then extended. And so I do think that that could be something that, even without understanding whether through the town of Erie, permitting, rezoning might happen, permitting might happen, and the timeline with which that could happen, that this may not be feasible regardless. And so if we are, as a commission, to look at that, I do think it's important that the operator also expediently look at that situation as well, to understand whether that is a hindrance and a proper evaluation of alternative 4. I will be, I appreciate the comments on the concern about impacts, potential public health impacts occurring at a variety of distances. And I think that that's, again, one of the things that sticks out to me. I know we spent a lot of time during the cumulative impacts rulemaking as well, discussing the fact that impacts can happen beyond 2,000 feet. What we focused on is expert testimony that said the reason we set the 2,000-foot setback is because the chances of public impacts occurring, public health impacts occurring beyond 2,000 feet diminishes greatly at that 2,000-foot mark. That doesn't mean that impacts can't happen. But as we heard from experts, if you're trying to put a risk on this, that's the level at which we do it. And so I do appreciate that there are 5 homes currently and an additional 72 homes planned within 2,000 feet of the proposed location. I do think it's noteworthy that there was informed consent provided for the 5 homes that currently exist. And I do think it is significant that the pre-production operations would occur before the 72 homes, planned homes in the future, would ever be occupied. And as Ms. Sorensen again talked about today, I do think that especially when you look at an electrified production site, as you look at a tankless site with three-phase takeaway, again, the impacts, the potential impacts to public health, safety, welfare, environment, and wildlife resources are minimized through those BMPs and through those actions taken. And so I think I'll just conclude by saying I feel differently about the analysis with respect to alternative 4. I was okay with the decision to move forward with a proposed alternative because I do think that there was valid reasons to not choose alternative 4. But I do understand and appreciate my fellow commissioners' concerns that they would like additional information on that, and I would be fine with additional information on that. Again, I just want to make sure that any such analysis can be done in an expedient manner so we're not stuck with a situation where this isn't a reasonable site, and by the time it's determined that it's not a reasonable site, the proposed location is gone as well. And then we've gone through an unnecessary process that would eliminate a very good application with the best-in-class BMPs that also has a lot of benefits with plugging and abandoning wells in the town of Erie, near homes, near high occupancy building units, near existing schools, that would also involve other things like the paving of roads, et cetera. So I'll leave it there. I would be fine with the staying of the application to evaluate further alternative 4.
Thank you, Commissioner Cross. I would move that we stay the application indefinitely and urge the applicant to work with the town of Erie on consideration of alternative 4, and also urge the town of Erie to work with the applicant on the consideration of alternate 4. Do I have a second?
Second.
Motion and a second. Further discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Are there any opposed? Motion carries. The Energy and Carbon Management Commission wants to thank all of those who have been involved in this application. I think that folks can see that this commission takes its work pretty darn seriously. And I think we've come to the right conclusion for today. And we'll look forward to working with the folks on this matter in the future after the direction from the commission is vitalized. Motion to adjourn. Do I have a second?
Second.
Motion and a second. All those in favor signify by saying aye. 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 We are adjourned. Thanks, everybody.